What should you know about trusts? Well, there are many types of trusts, and it's hard to know which one might be right for you. If you are interested in this topic or know someone that is, please listen in because Attorney Joseph Marra will explain.
You know who your children are, right? You have a good relationship with them and your spouse. There's no one suffering from a disability. You don't have estate tax issues. You only have property and assets in New York State. Normally, I would say, you really don't need a trust. Why bother? Because people think that if you do a trust, if you write a trust, that's good enough. It's not. You then have to take the assets and convey title to the trust. So it's like this glass, right? I have ice and water in the glass. Think of them as the assets. If the glass is empty, it's useless. I've had people come into me, oh, Dad did a trust. Okay, let me see it. So what assets did Dad put in the trust? I get a blank stare. Well, just doing the trust is not good enough. If they didn't put assets in the trust is absolutely useless. Now, as I said before, if you had all these proper things, you had no minor children, you had no disabled children, everybody got along, the spouses got along, the kids got along, there was no state tax issues, you had no assets out of your estate. The will was drafted properly, right? Properly drafted and witnessed properly. And there was an affidavit of the witnesses attached to the will. That's a long checklist, right? But assuming all those things were met, you didn't need a trust. Now, I don't feel that way anymore, and I'll tell you why. Before this whole COVID-19 pandemic, the surrogates courts in the New York metro area were getting very backed up. I mean, I remember like 5 years ago, I had a person with a relatively simple will, similar to what I discussed, properly drafted. Of course it was, I drafted it, properly witnessed, done right, no problems, put the will in for probate, letters testamentary, which you remember allow the executor to gather the assets and distribute them, literally issued in a week. Now, same circumstance, could take months. Things kind of get lost. The clerks are backed up. Now, the court system was in essence shut down during the COVID crisis for months. So you already had a situation where the courts were backed up before COVID even hit. Now you have things backing up even further. So before, I would say, don't worry about it. If you hit all the criteria, you don't need a trust. Now I don't know about that. I think most people should seriously consider a trust. Why people don't do a trust is, number one, the expense of it, and number two, they have to really transfer all their assets to the trust. You have bank accounts, they have to now go in the name of the trust. You have real estate, you have to transfer it to the trust. Stock, transfer it to the trust. It's a lot of work. But once you do it, everything's the same as it was before. But the problem is doing it. And a lot of people don't do it. Now, there are certain times when you absolutely need a trust. And let's examine that a little bit. If you remember, I told you if you don't have a will, New York State writes a will for you. Okay? And a lot of people, I try to explain that to people and they say, well, that's why I'm here. I'm here to do a will. Who cares what New York State does for you? Well, you might care. I'll give you a perfect example why. Let's say you're single, no children. Let's say you came to the United States from another country and most of your relatives are back there. Guess what? Your first cousins, let's say you have first cousins. They're going to be your heirs. You had no siblings, no nieces and nephews. The only thing you have is first cousins. If you had no will, they would get your money. So a client says to me, well, that's why I'm here. I'm writing a will. I don't want them to get them. I don't even know who these people are. What are you talking about? You can do whatever you want. You can leave whoever you want your money to in your will. Unfortunately, the people who would get your money, if you had no will, have to be notified And then, well, I don't even know who they are. Well, guess what? If you do a will and if you have assets through probate, well, those people are going to have to get notified. And I had one client say to me, you know what? I don't care, because anybody who's getting money from me is getting a bonus. And I'm not going through this expense and aggravation of changing around all my assets. So when I die, let them deal with it, which is perfectly rational if that's what you want to do. And actually, it was great for me. It was very interesting because I had this woman, she came here from Italy when she was a very young child. And all her first cousins, most of them were back in Italy. So what did I have to do in order to probate her estate? I had to hire a genealogist. I had to fly people in from Italy to testify to her family tree. I mean, she had maybe at that point a $700,000 estate, and over $250,000 of it went to legal fees, court costs, expert fees, research fees. So it was a wonderful experience educationally for me, not so much so for the heirs who eventually got the money. But these are the type of things that can happen. And like I say, you have to just know to make the choice consciously. Another situation where you really should have a trust is if you have properties in more than one state, particularly if you have properties in a state where the probate process is onerous. For example, 2 states where the probate process is pretty onerous are California and Florida. Now, a lot of people here in the Northeast, New York, New Jersey, Connecticut, Massachusetts, have second homes in Florida. They really should, if for nothing else, do a trust and if they intend on keeping that property for any length of time, put the house into the trust to avoid the Florida probate process. Another thing people don't realize, Florida found a way to make a little money for themselves. You can have by the way, how this would work is you have a will, it's probated in New York because if you're a New York resident, right? Then you have to apply for what's called ancillary probate in that other state. And guess what? Even though you name your executor in New York, Florida requires that a Florida executor be also named. So the court will assign someone who's going to get a commission. So that's another reason to avoid probate in multiple states. If you have property in more than one state, you really should have a trust, if for nothing else, to put the property in that trust. So today, should you have a trust? I would say more so than ever before. Before I would have said, if it's an easy probate, don't bother. Now I'll tell you, because of the backup in the courts that was going on before COVID, and now that's just been exacerbated by COVID, you really should seriously consider a trust and/or putting other people's names on some or all of the assets. And that's another thing I want to talk about. People say, well, I don't need a will. I have all my kids named jointly on all my assets. Well, once again, if things play out as you intend them to, that's a good plan. But what if they don't? What if one of your kids dies first? What if you don't have all your kids on all your assets and all your accounts? Some people say, well, I have an account for Joey and this account, and they're going around trying to balance. Like, okay, I got 100,000 here, I got to bring it up, bring it down. Why do you want to make yourself crazy? Put it all in a trust. Have them, it'll go according to the trust or the will or both. You know, people, I want to avoid probate. I want to avoid a trust. You can do that. But do kids die before their parents? They do. What happens in those circumstances? I'll tell you another story. Mom was getting older, and Mom said, well, you know, I'm going to transfer my house out of my name. I'm going to reserve a life estate. Meaning, the life estate is just something that says, I have the right to live in this house for the rest of my life. And when I die, it goes to my kids. Seems like a perfectly good plan, doesn't it? Well, Mom had 3 kids, and guess what? One of the kids died before Mom. And guess what? The kid didn't even live in the United States anymore. The kid had taken a job and lived overseas, as did the children of this child. And then guess what? Mom moved out of the house before she died. And then Mom got disabled, and Mom had to go to a nursing home. So this plan that seemed like such a great plan well, I'll leave the house in my name alone with a life estate. And when I die, the house will go to the kids, avoids probate, don't need a will, don't need a trust. Well, now it's a disaster. So if things go as planned, some of these ways of avoiding probate, avoiding trusts will work. But as you know, life doesn't always go as you anticipate, and you really have to prepare for all contingencies. Absolutely, there are many, many types of trusts. But what we'll just talk about, and we spoke briefly about inter vivos, meaning living trust, and testamentary trust. Those are trusts created in your will and are not officially created until the court sanctions them. Now, in the context of living trusts, inter vivos trusts, we'll focus on the two main types of inter vivos trusts: revocable and irrevocable. Now, revocable trusts are the typical types of trusts that people use to avoid the probate process. So once you set up a revocable trust, that means you could change it at any time, modify it at any time, do whatever you want. In that sense, it's very similar to a will. Until you die, it's completely fungible. You could change it at any time. And once you transfer your assets to that trust, you treat them exactly the same as you did before they're in the trust. So people say, well, can the trust own stock? Well, absolutely. Can the trust own real estate? Of course. Can the trust even own jewelry? Yeah, it can. And with a living trust, it's fungible. You basically put whatever you want in, take whatever you want out, do whatever you want. The key to it, if you're going to use that living trust to avoid probate, is to get every asset in there. I had a client who was from Eastern Europe. We set up this revocable trust for him. He had no relatives here that he knew of, other than these cousins who he hadn't seen in years. And I set up the trust for him. I transferred his real estate to him, helped him get started transferring some stock to it, and went on his merry way. Well, 2 years later, he died, and he left approximately $500,000 outside the trust. So, of course, for that reason, we do what's called a pour over will. The will says, I leave all my money, to the trust. But now these first cousins are now fighting over this. They say, well, we want a piece of this, even though they didn't even know the guy was dead for a year until they were notified by our office that he died. So you really want to put the assets in the trust if your purpose is to avoid the probate or intestacy process. Now, as I said, revocable trust is the one class, irrevocable is the other class. Why would you use one over the other? Well, irrevocable trusts are used a lot of times if you have an estate tax issue. So classic, you're going to be paying an estate tax. You know it. Your assets are, $20 million and you're going to be paying estate tax. You're single, $20 million, you're going to be paying estate tax. So what you might do is you might set up a irrevocable trust, meaning you can't revoke it. And then you have that trust buy life insurance to pay the estate tax bill and set up the trustee. And then you basically every year put in the premiums into that trust. The trustee pays the premiums. And when you die, what happens? The trust pays the estate taxes, assets tax-free. So just as an example, you had a $20 million estate, you would have paid, let's just say $4 million in taxes. You set up an irrevocable life insurance trust, and you have to put the trust buy a $4 million policy, and you put the premiums every year to pay the policy. When you die, the policy gets $4 million tax-free. It then used that money to pay the estate taxes on your estate, and your heirs get your $20 million. That's one way we use irrevocable trusts. Another way is for what's called Medicaid planning. What do I mean by that? Well, that's a whole nother discussion, which we'll have at another time, about qualifying for Medicaid. But the bottom line is, if you put assets into a trust and they are there, it's once again an irrevocable trust, and they are there for at least 5 years, then those assets are not considered for Medicaid purposes. Just as an example, you had $1 million and you put $700,000 into this trust 5 years go by. Now you have to go into a nursing home. If you had to file a Medicaid application because you otherwise ran out of money, this money you put, the $700,000, you put into this irrevocable trust, assuming the trust was properly handled during the 5 years, it's out of your estate for Medicaid purposes. So when you die, your children will get the money and Medicaid will pay your bills. So those are kind of the two main reasons why you would use an irrevocable trust. Are there others? Absolutely. Among them being caring for a child with special needs where you have money. So there are a lot of reasons why, but those are the two main reasons why you'd set up an irrevocable trust, a trust you cannot revoke, as opposed to one you can revoke.
Thank you so much, Joe, for that important information, and thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options. We look forward to hearing from you soon.